Doctrine of constructive notice. Doctrine of constructive notice is one of the important doctrine which is specifically coming in the chapter Memorandum of Association and Articles of Association. As we all know, Memorandum of Association and Articles of Association are public documents of the company. Since they are public documents, we can download those public documents by paying a very nominal fee. Basically, like Memorandum of Association and Articles of Association, by downloading that and viewing those documents, we will get to know the authorities of the company as well as to what extent the board of directors can act on behalf of the company. Those documents will be specifically, or those informations will be necessarily available in the Memorandum of Association and Articles of Association. It will be presumed that if a person wants to enter into a contract with the company, there is no necessity for the company to explain the provisions of Memorandum of Association and Articles of Association every time. It will be presumed that since the Memorandum and Articles of Association are already available in public domain, the person entering into the contract has full knowledge about it. He has read the provisions of Memorandum and Articles as well as he has understood the provisions, and then only he has come forward to enter into contract with the company. This is what the presumption which is going to happen in doctrine of constructive notice. The basic reason why this doctrine of constructive notice has evolved, this is to protect the interest of company against the outsiders and to protect the time which is involved in management of the affairs of the company. But taking shelter of this particular provisions, company cannot cheat its contractors or the company cannot cheat its customers. That is the reason why we have one of the important doctrine as an exception to doctrine of constructive notice. It is doctrine of indoor management. Doctrine of indoor management has evolved from one of the important case law, Royal British Bank versus Turquand. It is very famously called as Turquand rule. The facts of the case is like this. What happens, a board of directors will issue a bond of Royal British Bank to the petitioner, that is Turquand. With the authority, two directors will sign the bond and then they will give it to Turquand. It will be stated in the Memorandum of Association, while executing the bond or borrowing the loan, it has to be signed by two directors as well as that particular transaction has to be approved by way of passing a resolution in the general meeting. Turquand, by looking into the provisions of Memorandum of Association, he understands that sufficient approval would already be taken from the shareholders of the company, and with the authority, board of directors has executed the bond and they have given it to the Turquand. Later on, it will be discovered that the board of directors would not have taken approval from the shareholders of the company. The doctrine of indoor management specifically says that Turquand, what he has specifically seen with respect to minimum two directors have signed and approval is taken, there is no necessity we need to get into the details of the company whether specific approval is taken by way of passing a resolution in the meeting or not. That specific need will be specifically called as the internal regulations of the company. An outsider need not specifically look into the internal regulation of the company. If we see on the face of the document, Memorandum of Association and Articles of Association, that could be sufficient. So basically, there is nothing to do with the internal management of the company. If we see the contents of the memorandum and we have understood the contents of memorandum and articles, that would be a sufficient requirement under law. This will be the basic difference between a constructive notice doctrine as well as doctrine of indoor management. Doctrine of constructive notice will be to protect the company against the outsiders, and doctrine of indoor management will be to protect the outsiders against the company.